Aloha. Welcome to American Issues Take One. I'm Tim Apicella, your host. Today's title is Supreme Court of the United States Judges Gaslight America. I don't know why it was, but somehow I came across the Senate Judiciary Committee's notes, transcripts of the nomination process for John Roberts. And guess what? I noticed at the very beginning of that transcript, and I forgot this, that every nominee takes an oath that they'll tell the truth, the whole truth, and nothing but the truth. And then I started thinking, well, wait a minute. I was watching the nomination process for Brett Kavanaugh, Amy Coney Barrett, Neil Gorsuch, and it seems to me if John Powers took the oath to tell the truth, they had to do the same thing, and I do recall them doing that. And in that testimony for all of those judges, they stated explicitly they saw no need to overturn 50 years of established law, and I'm referring to the Roe v. Wade case. Yet, lo and behold, not much later, they all sided with Dodd v. Jackson, which overturned federal protection of abortion rights for women. So what happened to that oath? What happened to their testimony? And that takes us to the title of this show. Are these judges gaslighting America? And with that, I'd like to go to my guests, Jay Fidell, my co-host, and our esteemed special guest, Ben. How are you, Ben?
I'm doing great. I'm doing great.
Great. Well, thank you for taking the time to join us. And I'm going to go right to you. What's going on here with the judges saying one thing in testimony during the nomination process and then reversing course to reverse 50 years of law? And it doesn't just apply to Roe v. Wade, but we now have the case of affirmative action, 50 years plus years of affirmative action, suddenly reversed. That's established case law.
The answer, I would say, is yes, at every confirmation hearing for one of these justices on the Supreme Court. I think that everybody who brings them up, whatever the president, is reminded of what happened to Judge Bork when he had the Bork confirmation, where Bork actually said what he thought, and he didn't get confirmed. So the question is, okay, how do I dance around the subjects in a way, and then in my private meetings with the senators, try to reassure them, but whether they in fact are going to do what they say, it's up in the air. There's another layer to this too. For example, with Kavanaugh, right? I thought there were hundreds, if not thousands, of tips about Kavanaugh that were provided to the Department of Justice, okay? About this thing or that thing, there were the issues that were raised about him. But the way it's structured is that you actually don't have an FBI investigation. All those tips go to, guess where? The White House that nominated them. And they decide what they're going to do with it. And that's the way the game has been played forever. So the end result is when they say the FBI looked into it, it's in fact, it got sent back to the White House.
So there's a clear example of being gaslit.
Oh, yeah. Oh, absolutely. Absolutely. Another one is, since you spoke about affirmative action, was with regards to Chief Justice Roberts for his confirmation hearing. There was a memo when he was either at DOJ or at the White House. He wrote, as a lawyer there, about affirmative action, right? And it was at the Reagan Library. Okay, unfortunately, the memo disappeared. Okay, and the only thing that was left were the notes that were done by guess who? The president's men or women about what was in the memo. So you couldn't see what he had actually written as advice, which would have been useful as part of that confirmation process, where you could imagine a senator asking that question. So, yeah, there's a lot of gaslighting going on. And I'm not even talking about the actual decisions themselves.
So I've always been curious, Ben, what is the difference between what appears to be an obvious case of gaslighting, fib telling, whatever you want to call it, versus borderline perjury? Is that a possibility?
Well, let's take one case that's come up since last week, which is the case was a Creative 303 LLC, the web designer artist case, right? So it's come out since then that there was evidence of some gay guy who supposedly tried to get business with her or something like that. And the guy came out and said, I never contacted her. I've been married for 15 years. So this is part of the evidence that went up through the courts from the beginning as part of that case. Well, when you're a lawyer, you're representing your client, but you're also an officer of the court. And one of the very serious things with regards to that role is a fraud on the court, and that there could be sanctions. Now, I haven't been able to find it, but I heard that the Colorado Attorney General apparently has been seeking an injunction on that decision of the Supreme Court in light of this thing coming out. So there's one thing right there.
Do you think that the court knew this was a hypothetical case and they had a political desire to address it on a, because let's face it, we have a lot of conservative Catholics on the Supreme Court. They're judges that are well steeped in their Catholic faith and their interpretation of that faith. Do you think that was something they were desirous as to opine about and make a decision on, even though it was hypothetical?
Well, I think that they reached out to opine, yes, but I would put it in a different place. I would put it on there's a doctrine called standing, which is like you should have an injury so you can bring the case to court, right? Okay. But here's a person who was thinking about, I love this. I'm thinking about doing this, okay? But I'm worried about having a problem, right? I'm looking, where's your injury, ma'am? Where's your injury? Why do you have standing to bring this case, And, but they reached out and they blew through a lot of standing, I think, jurisprudence in civil procedure that with regards to reaching out and concluding that this person had standing to bring their case. But here's another twist on that. Say some gay person, she writes now on her website something along the lines that I hate gay people because God told me to, or something like that, right? Some gay person goes in, she says, I'm not going to do business. That gay person sues her under the Colorado anti-discrimination law. Then you get the Supreme Court's going to say, well, that's between private parties. There's no state action, so there's nothing for us to do here, okay? So this was the kind of thing that went on for all those years with regards to, racial covenants and deeds and all that stuff. There was no state action. It was just private stuff going on until they realized that, when the court acts, that's state action, so that's where it comes in. With regards to them being Catholic, well, we have a pope, right, who has been very, I don't know if the term is progressive, but he's been one who's basically said, hey, it's not a sin for somebody to be LGBTQ, right? Now, obviously, there's the conservative wing of a church and, the liberal wing and all that. And, obviously, some of the conservatives are not too happy with that, right? But whether the Supreme Court is they're influenced by their religion, I mean, all of us are, but you're supposed to be looking at the law, does it impact them? We all, there's a realist theory of judging, which is that judges are creatures of their time,
Yeah.
But the thing is that they went a long way, I think, more for a conservative agenda than anything else to basically put this free exercise, this free speech basis in that case, which I find very disturbing. I mean, can you imagine? I don't know. You want to go do some business somewhere, and this person says, we don't do business with Hawaiians. Mm-hmm. That's how I feel. I have a deep feeling because I think Hawaii is X, Y, whatever. And you have to listen to that. Now, that speech they're saying is protected, but would you be comfortable going and pushing against that in trying to get the business done? We heard you were the best at it. We want you to do it. And then you get the issue of is their conduct refusing you would be a secondary thing.
Well, let me jump on that point and direct that to Jay. Jay, was the 303 Creative LLC versus Elena's case more about reversal of public accommodation versus a First Amendment provision? Either or. Okay.
No, it was anti-gay is what it was. And 6 of those people had a little understanding they weren't going to support anything gay. And they threw out not only the standing issue, Ben, but also the case of controversy requirement. If I went to any court in the land without a case or controversy, and the court decided it without a case or controversy, the appellate court would throw it out immediately.
Yep.
Credibility of the Supreme Court to take on a hypothetical case without standing.
Badly. But then, at this point, the Supreme Court has no credibility, so it's not a surprise they're doing things in disregard of their credibility, because apparently they don't care.
Well, Jay, we've talked about the Dodds case and how that was a reversal for at least 3 judges that said they would have no interest of reversing 50 years of established law, yet they did it. And then we have this 303 case, and then we have the college admission case. Of these 3 cases, which one do you think provides the most and greatest example of gaslighting Americans?
Well, I think there's 2 examples of gaslighting Americans in the scenario you described. One is when they come down in front of the Senate and they testify. And, we all looked deeply into Kavanaugh's face, and we all knew he was lying. We all knew it. And I would suggest to you the Senate knew it too. It was a little theater game that was played by the conservatives. And so when he lied like that, it was gaslighting America for sure. We had a show about similar issues last week called Gas from the Top. These guys have all these fancy, credentials, and they go and they lie to the American public. I think it's really interesting, Ben, and thank you for mentioning it, that there is no FBI investigation. It goes directly to the White House. And in that case, it was Trump, and he was going to do everything possible. You remember in the Brett Kavanaugh confirmation, Kavanaugh went into a rage, you remember? And
yeah.
It was a distraction rage. And as I recall, it came from Trump. Trump was managing the theater. He was managing the outrage. Just so they could get off the point. The whole thing was just theater for the conservatives, for the Senate, and for the public. I don't think the system is working very well when that happens.
You of course remember the high-tech lynching one of Clarence Thomas back in the day too. When he was up with the Anita Hill thing. I mean, I'm sure that was being played a certain way. To freeze everybody. Oh my God, I can't be seen as racist with this black man. But I keep getting these memes today. Anita Hill told you. Anita Hill told you.
Well, it's true, and I will never forgive Joe Biden for being his advocate. Mm-hmm. He really contributed nothing to the court while he was in the minority. And now that he's in the majority, he's terrible. What a judge! My goodness gracious, he's going to go down in history. If he was faithful, to the Black constituency, he would be able to do remarkable things for this country. But he's not. And he's doing terrible things for this country. I'm sorry. Anyway, we'll go to the second point of gaslighting, Tim, to answer your question. The second point of gaslighting is all these opinions they're handing down. Junk. I mean, a first-year law student would do better. They are inconsistent. They are not based on precedent. They are twist of words. They'll say anything to get where they want to go. And what you therefore have is a court that has an agenda, as Ben said, and they're going to play that agenda out no matter what. And so, what happens is a case comes in the door or comes in for vetting, and they say, well, let's see, we want to do this. Now, how can we get there? And then they come up with this, really gaslighting kind of analysis that gets them there. And in a sense, these guys went to good schools. I don't know what happened to their legal education. And the 6 of them get together. It's kind of a conspiracy. It's a conspiracy to create a new kind of precedent. The precedent is you can predict where they're going by looking at the conservative agenda. That's the precedent. It's not the law. It's the conservative agenda every time. And it's quite remarkable. And that, gentlemen, is gaslighting.
Right.
So the gaslighting got two levels.
Well, I would propose a third level. And Ben, to you, we have case after case, judge after judge on the Supreme Court that is involved with serious ethic violations of accepting all sorts of freebies and gratuities. And their explanation to the American people is, don't look here, no big, keep on moving on. Nothing to see here. There's a third gaslighting, and that is them downplaying the acceptance, what appears to be non-tangible or even tangible kind of bribery type stuff. Your thought on that?
So you are hitting on what I think will be hopefully a very interesting thing over the next few months, because Alito and Thomas got an extension on their financial disclosures for 3 months, which they are allowed to do under the rule. But from what I understand from ProPublica, Thomas, $3.8 million not of things that he had not declared. Gorsuch got his house bought by some big law firm guy at a nice, sweet price, right? Just when he got on there. Alito with his friends going on that Alaska $100,000 freebie trip with that big billionaire. Chief Justice Roberts' wife doing headhunting for the big law firms, coming in with $8 million worth of stuff. And it's presented as salary as opposed to what it was commissions, right? Okay. See, I haven't seen Amy Coney Barrett. I haven't seen anything with regard to her at this point. And then Kavanaugh, but I know the other thing is there's something to do with the Antonin Scalia School of Law. Okay, my feeling is that in the background of this, you got to look for this guy Leonard Leo and the Federalist Society and people like that who maybe are matching up people, matching up billionaires with particular ones or all. I don't know exactly how it's all being played. But there is a lot of stink right there now, and that is so appalling, not only for just me, Joe Schmo, but for judges in the system. I know judges who won't take a cup of coffee from somebody for fear of an ethical violation, and then you find in these people, it's like you find out everybody's getting drunk at the bar at the Supreme Court deliberations. You're like, what the heck is this? So yes, I think that is very, very serious, and I don't know where it's going to go, but I hope it goes where it should go, which is like, let's see. Now it's been flipped over to the Judicial Conference, which I understand that, but the Judicial Conference, they're ambitious, right? Just like any other judge to be moving up, and so you got to see whether they can actually do something in this setting. But this is a very serious.
I guess that leads me to a question I was going to ask towards the end of the show, and that is, where does this lead us as far as ethical reform for the Supreme Court? And where does this leave us with the possibility of introducing the concept of term limits?
I would say that if Congress passes ethical reform, the Supreme Court will say we're co-equal branch. We're co-equal branch, and you can't do that to us as the Supreme Court. Okay, there'll be a whole argument, but they say we got the last word. So, but with regards to term limits, that would be another one of those battles between co-equal branches. And Marbury v. Madison, the Supreme Court have the last word. I'm not sure. The space that I see is actually a little different, which is just somebody at the Justice Department has the willingness to file a criminal complaint against somebody, and we go down the criminal path, because there have been cases with judges in different settings who have been subject to criminal complaints for things that they did, like taking bribes and all that stuff. I just see that at least for purposes of violation of disclosure rules or something like that. Here's another one that I'm just thinking about. Thomas did not recuse himself from the January 6th stuff when his wife, Ginny Thomas, is like involved with contacting 27 legislators in Arizona, trying to get them to overturn the election. I mean, it's so enormous that, I mean, I don't know, you or me, we'd be like, of course we have to recuse ourselves. Is that there's blind spots too. It may be that they're so blind in the way they think about things, they don't even see that they're gaslighting. You know what
I I get that point. Jay, same question to you. As to what degree will ethics reform enter into the Supreme Court, and to what degree does the notion or the topic of term limits enter the possibility of the Supreme Court reform?
I'm sorry to report it's not likely we're going to have term limits while we have the Congress in such a disarray. If you need congressional action at the least for any reform, and they're not going to reform the Supreme Court. They're just happy as punch the way things are going, and as long as they retain the ability to either stop or block any action to reform the Supreme Court, that's not going to happen. It's going to be a long time, gentlemen. Mm-hmm. The other aspect of this is something that one of you mentioned, which I find very interesting. In the case of controversy in the website development case, and the Attorney General of Colorado comes and says, we're not going to follow that law. It's not based on a case of controversy or standing, whatever. And it's bad law. And it's bad law, and they never explain why it could possibly be good law. And so we're not going to follow it. Now, that's pretty aggressive.
Yeah.
But, there are people out there that might do the same thing. And the Supreme Court does, at least logically, have a cap on it. They can't opine something without explaining it, the shadow docket and all that.
Right.
They can't opine it without explaining it. And if it doesn't fit, common notions all the way back, stare decisis, and even English law common notions, we aren't going to follow it. Now, that is just an unbelievable turn of events in this country.
Didn't we have that in the 60s when integration of schools was being refused? And I recall Governor George Wallace, standing in the doorway, and there was a refusal to integrate. And so didn't the feds have to threaten to pull money from those states, and all sorts of, weren't troops sent down to ensure that integration took place?
Yeah, he had marshals and U.S. marshals, which is one of the most hilarious stories. Nicholas Katzenbach was one of them. And, he's basically a lawyer. And they say, okay, you're a marshal now. You got to go down to, Alabama, help this black student get into the classroom. What do you know about being a marshal? But he did it, But, so there's this doctrine that was tried to develop right after Brown, right? Interposition. That was this idea of the state could interpose itself, right? That didn't succeed because why? You had the federal government that was basically there supporting the decision of the court to enforce that decision, right? But what if you have a federal government that isn't going to support the decision of the court in that setting? They're going to acquiesce in all kind of craziness happening at the state level. It's something really important because, in addition to these battles being played out in the federal courts, there are a lot of organizers with money in states to have laws changed and policies changed to weaken a lot of what we would think would be good rights. On next Wednesday, July 12th, there's a guy giving a speech here in Charlottesville from an organization, Do No Harm Medicine, right? And they're complaining about woke medicine, right? And trying to get all kinds of changes to how healthcare is done because there's woke healthcare and woke. I want to go because I got to see this routine. You know what I mean? It's like, but I watched a couple of his podcasts, and he's very intent on disseminating and impacting state level stuff, right? To change things at the state level, and there's a lot of that going on.
Jay, you hit on a really important point, and that is, here's a decision the Supreme Court made, and presumably we have some credibility issues with the Supreme Court. What happens if states, regardless of which way the Supreme Court has ruled on a case, starts to ignore it? Where does that lead us to?
I actually think there's a fair possibility, at least with some issues, that that's going to happen. You don't have a lot of options if you're a right-thinking jurist or judge, for that matter. And when they do something off the wall, maybe you don't follow it. Maybe legislators don't follow it. Maybe
is that a constitutional crisis?
Well, it's it's a judicial crisis anyway. We've lived our whole lives with utter esteem and respect for the Supreme Court, but that is over.
Yeah.
Not only because of their cockamamie decisions and their obvious agenda decisions, but also because of the corruption that's coming out on a regular basis. How can we respect them? How can they expect respect? How can the federal and state judges under them respect them? How can the legislators, right-thinking legislators, I shouldn't use the term right-thinking, how can the clear-thinking legislators respect them? How can the public respect them? I think they've already lost it, except in Moore v. Harper. That was a good decision. And I think they throw bones once in a while with this very notion in mind. They don't want to lose all their credibility, but little by little or big by big, they are losing credibility, and the country is not going to respect their decisions. And you can call that a constitutional crisis, but it is a crisis in law for sure.
So if you're the Biden administration, what's the remedy? Or the next administration, whoever that may be?
Let me go back to some. I guess this is a point Ben made: is why not prosecute somebody, whatever level of judicial authority he or she has, for a violation of law, for corruption on the court, for taking bribes. Obviously, Joe Biden is not going to investigate them. Merrick Garland is not going to investigate them. There's no sign of that. Jack Smith is not going to be brought in for that. The FBI is not going to touch it with a 10-foot pole. They've already demonstrated how their view of how you deal with political issues. And so I don't think that Joe Biden is going to do anything. The next generation, it's hard to imagine. I'm trying to imagine a younger president. I'm trying to imagine a liberal, call it a woke president, who would do something about it. At the least, he would get up on the bully pulpit. One of the criticisms is the ABA has done nothing about this. Judicial Conference, not yet. And the Judicial Conference has really distinguished itself as, not being active about this at all, not even speaking about it. And so I'm concerned that the bar will not police itself. The judiciary, they're passive at best. And we are going to have a continuation of this until we, either get some new judges on there or reform the court. We're in deep kimchi, gentlemen.
Yeah.
No two ways about it. Hey, we've run out of time, but I had to get this question out in this show today, and I didn't get to it, but I want to do it now. Ben, regarding the admissions Supreme Court decision, California had, I think, eliminated their requirements. I don't know if it was 10 years ago or some years ago. And they're using something called the adversity scale, which is to say, as a student, describe your life and the adversity that you have been subject to and how you would make a difference if you were to be admitted to this college and turn the tides on adversity for other people. What's that all about? And is that a fair replacement?
My thing is really kind of like, okay, America, I love, we got to go in terms of euphemisms, right? All the time. Well, let's talk adversity now, right? Oh, adversity is neutral, so we can talk adversity, right? And I'm like, okay, maybe that works, in terms of trying to have a diverse, student body and all that. I've heard some good things for UC Davis's medical school that has been working successfully there. But one of the things about the Supreme Court decision was that that one of the things with the Supreme Court decision was that the student could write anything they want, about like they were, let's say they were the child of a black mother, a sharecropper, dumbest sharecropper in Mississippi or some state like that. They could write all that stuff, and that's been generations back to the Civil War. Before that, they were slaves, yada, 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 yada. And then, and they managed to do well and all this stuff, and they write all that. I mean, it could be a beautiful story, right? But then what is the admissions office supposed to do? Because they've been told you can't take race into account. All right, well, how do you deal with this person's statement that is all about their racial experience? And that's where I think is going to be the problem, because even if you use the adversity, if your adversity is something like that sharecropper story, yeah, but you can't take race into account. So,
Well, not only that, but how do you verify the adversity?
Oh, yeah, well, that's another thing,
That's a whole other thing. I was reminded of a game show as a child I was forced to watch. I was a very young child, called Queen for a Day. You have contestants. You have three contestants tell their story of woe. And whoever got the sympathy of the audience through an applause meter, they were the winning contestant, and they wore a rat mink stole and a cheesy crown. And bottom line is this nothing more, the adversity scale, nothing more than an expanded version of Queen for a Day?
That is really funny that you mentioned that, because when I was a little kid, I wrote a letter, because they would ask you could write in something to Queen for a Day, and something you could win or something like that. And I have a memory of watching the show and the guy saying Benjamin Davis. Okay, I mean, maybe it's a little kid thing, like 8, 9 years old, But I swear, I was like, what, But he got my letter anyway. But yeah,
wow. That show lasted about half a year, and they said it was cruel to human beings, and they yanked it.
Oh God, that's funny. That's funny.
Yeah, but, Jay, I don't know how I got on that tangent, but I did. Your last thoughts? Sorry about that. It was a bad analogy. Jay, your last thoughts on this topic? Gaslighting, Supreme Court gaslighting Americans.
I want to go to that adversity application. I don't think it's the best answer. Reason I say that is it's going to be kind of a coded message of race. Obviously, I mean it's inherent in the whole approach. It's a coded message of race. It's to say, look, I'm in a minority. I want your help, and let me explain why I'm in a minority and how life was, whatever it is, sharecropper, whatever. And so it's not quite honest, It's a coded message, kind of thing that Trump does. They're giving coded messages, and he gets the message through, but it's not the truth. And you're right, it wouldn't be verifiable very easily. I think what we want is what we had. And what we had is, it's affirmative action. And it includes not only the people who've had a tough childhood and a tough background. It includes everybody who's of a certain race, because our calculation, our surveys and studies show that not enough Blacks have gone through these schools. And it's really regrettable that we don't have that anymore. So if the memo suffices, good. Bad cases make bad law, and people find a way around it. Just like in the Dobbs case, they find a way around it. But it's not what we really prefer at all. What we really prefer was a law that was in place for 40 or 50 years that everybody relied on, and that helped the country. We need to help the country. We have such serious race problems in the country. And this court is going the wrong direction, and it is doing such damage and destruction to our society, and that we are all totally offended by it. So all I can say is the Supreme Court has let us down and will continue to let us down unless we have some dramatic change.
Two things.
Of course.
Okay. So one is there's a new case that has now been apparently filed against Harvard with regards to its legacy and donor admissions just in the last few weeks, okay? And we'll see what in the last days, actually. So it'll be interesting to see how that plays. Personally, I find it ironic that once you've had a few Blacks browns, Asians admitted to Harvard who could run legacy. Let's get rid of legacy. Okay. I personally have this wonderful image because in the Supreme Court affirmative action, one of the decisions, it broke out percentages the last 15 years of Blacks, Hispanics, and Asians, right? And I said they should have gone back to 1636, okay, and had whites and by gender. And it would have gone from 1636 for 333 years, would have been all white men, except for W.B. Du Bois, maybe 1 year, and maybe an Asian or Hispanic there. And so then 1969 is the date I'm looking at. And then maybe they got these numbers here. But that would have been just a wonderful graph to see. You know, it's like, yeah, okay. But the other thing is just on Dobbs. How is it possible for the Justice Alito to go back to the 13th century in his analysis traditions, and he does not mention 250 years of Black women in slavery and them trying to control their bodies? You know, I found recently the name of my ancestor who gave 6 kids to William Henry Harrison, right? 9th president of the United States, right? Slaves can't consent. It's rape, okay? Her story, his blind spot was so he could not talk about any of those stories about, you know, those women trying to control their bodies, let alone women not being able to vote until 1920. So every law that was before 1920 was made by a bunch of property white guys, basically. Nothing about that. I'm like, this is amazing. You know, this is just like insane. But that's just me, okay?
No, so, that's where the court is going, Ben. It's going to take every opportunity to restrict voting. So we thought we had worked that out. We didn't work that out. This court is going to reverse things, including voting rights.
Absolutely, they're going to try to. But I'm going to say this: I don't despair. I never despair, because you know there was Dred Scott, right? And people worked after Dred Scott. There was Plessy, and people worked after Plessy, right? There was Brown and massive resistance, and people worked after. I mean, I can take every kind of case where there's been something bad happen. There was the 1924 Immigration Act that led to Senator Inouye's mother losing her U.S. nationality because she was born in Japan, right? But there was the 1965 Act that opened up immigration. There's always, you know, the effort to be put in to make the change happen. It could be in the legislative, it could be in the executive branch, even if the court's going to be backwards, right? But it could be in just private business, private sector. But you know, there are spaces where you can move the change forward, notwithstanding that you might have some kind of gaslighting was a euphemism too, kind of.
I admire your optimism, but waiting 100 years or 50 years for a reversal of bad law is a little tough to swallow these days.
I think it's really, I would like to agree with you. I really appreciate your optimism. I also appreciate you coming on the show, the American Issues Show. It's great to have you here.
Thank you.
But I think before I agree with you and share the optimism with you, I'd like to wait and see what happens in November 2024. I'll get back to you on that.
All right. And I'm just saying, I'm not saying optimism. I'm just saying I'm not despairing, okay?
That's a good distinction to make. Appreciate it. You know, we've run out of time. And before I say goodbye and thank our guests, you know, I mentioned that the game show Queen for a Day was taken off the air because it was a horrible insult to human dignity. I'd like to think that some of these recent decisions by the Supreme Court would also be in the same category and taken off the air as well. So with that, I'd like to say to my co-host, Jay Fidell, thank you so much. And to our special esteemed guest, Ben Davis, thank you so much for taking the time to appear on American Issues, Take One. I'm Tim Apicella, your host. And why don't you join us next week? And until then, aloha.
Thanks so much for watching ThinkTech Hawaii. If you like what we do, please click on the like and subscribe buttons on YouTube. You can also follow us on Facebook, Instagram, and LinkedIn. And please check out our website. That's thinktechhawaii.com. Mahalo.